Speaker. May I begin by congratulating my honourable friend for securing this debate. He has shown his usual tenacity and principle, which are becoming his hallmark. It is also a little bit of a relief on this one-line whip to escape the burdens of PPSdom and be able to speak out on something that I have felt passionately about for some time and indeed have written recently a pamphlet on, which will be published shortly, entitled the Case Against the European Arrest Warrant. I won't trespass on my time and speak a lot about the United States, except to say and place on record my support of and sympathy for Gary McKinnon and his family, who have been, in my judgment, very badly treated, and the public share that view very strongly. I'd like to concentrate on the case of the European Arrest Warrant, and reflecting on that, the moderation that my honourable friend's motion, the words it uses, where it calls upon the government to reform the UK's extradition arrangements to strengthen the protection of British citizens. I think, as the honourable gentleman for Aberavon who's just spoken said, there is a consensus emerging in this House that there is something the government should look to do. It has been alluded to already, the context, the political and emotional context in which the European arrest warrant emerged after the desperate events in New York on September the 11th. Indeed, in written evidence, the Parliamentary Joint Committee on Human Rights, the then Liberal Democrat MEP, Sir Graham Wilson, who at that time was chairman of the European Parliament's Justice and Home Affairs Committee, said the proposal would still be on the shelf, gathering dust, if it had not been for the events in New York. Mr. bin Laden helped make it a reality, and I think there is a great truth to that. The whole purpose and workability of the European arrest warrant hinges upon the principle of reciprocity between our courts, our system and other courts. And I won't dwell on this because I think my right honourable friend, the member for Halton, Price and Howden, and my honourable friend who introduced the motion spoke passionately about why in many cases that is not a reality. Another thing that is central to making the European arrest warrant work is that of proportionality in its application. On the 9th of January 2007, the Presidency of the European Council delivered a communiqué to the body's Working Party on Cooperation in Criminal Matters, examining the application of the proportionality principle in matters relating to the European arrest warrant. The proportionality principle, as included in Article 5 of the Pre-Lisbon Treaty on the functioning of the European Union, stated, "The proportionality principle is applied in respect of the four freedoms of the European Union, chiefly the free movement of goods, services, persons and capital." The then treaty stated that any action by the community shall not go beyond what is necessary to achieve the objectives of the treaty. But it is surely clear that in application the European arrest warrant has gone well beyond what is proportional in its use. Look at some of the examples where warrants have been issued. Warrants issued in respect of offences such as possession of 0.4 grams of cannabis or 1.5 grams of marijuana, the possession of 3 ecstasy tablets, the theft of 2 car tyres, and even the theft of a piglet. Or the case of a person arrested whilst driving a car with a blood alcohol level of 0.81 milligrams compared to the UK limit of 0.80. This has been recognised even by the European Commissioner with responsibility for justice matters, justice and fundamental rights and citizenship, of course, where she stated in November last year, European arrest warrants should not be issued mechanically or automatically for crimes that are not very serious, such as bicycle theft. And then, Madam Deputy Speaker, there is the question of numbers, and this is actually also, I believe, fairly central to the application of the European arrest warrant. In 2009, the total numbers of arrest warrants issued were 14,789. My honourable friend, the mover of the motion, will doubtless be aware, and it backs up his point about the differences in other systems, that Bulgaria, Hungary and Italy were unable to provide figures for the numbers of arrest warrants issued in their countries. Poland issued 4,844. France, similar-sized country to the United Kingdom, issued 1,240. In the United Kingdom, we issued a mere 220, and then look at the numbers as to where those citizens were living when those warrants were issued. So despite the United Kingdom being in the bottom quarter of issuers of warrants, warrants issued against people in the United Kingdom represented a total of 38.8% of the total warrants issued across the whole of the European Union.
Top of the league.
Top of the league, as my right honourable friend says from a sedentary position. There is a fundamental question as to whether the European arrest warrant is compatible with habeas corpus as we understand it in this country. The excellent Lord Vincent of Rotherham Dean challenged the Home Office Minister then responsible in the other place, where he said the fact remains that hundreds of UK citizens are being compelled to appear before another EU court without the merit of the often frivolous charges first being assessed. They can be locked up without pre-trial. Is she not concerned that this totally overrides the ancient liberties of the British citizen enshrined in Magna Carta and habeas corpus? Will she assure the House that this will be resolved? The then Minister Baroness Neville-Jones responded, "My Lords, the Government are concerned with the disproportionate use of the European arrest warrant for trivial purposes." Another example of the consensus emerging across this House. Then, Madam Deputy Speaker, there is the question of the dual criminality principle. Under the European arrest warrant, British citizens or those living in the United Kingdom are able to be extradited to another European country for crimes which may not necessarily even be offences under United Kingdom law. These concerns have been raised by the Home Affairs Select Committee in their report into the application of the European arrest warrant in November 2002, in which that committee stated they had grave concerns about the abolition of the dual criminality safeguard on the basis of the variety of criminal justice systems and of legislative provisions within the member states of the EU, which make it difficult for us to be confident that it will be acceptable in all circumstances for a person to be extradited from the UK to face proceedings for conduct that does not constitute a crime in the United Kingdom. Madam Deputy Speaker, the fact that the European arrest warrant could necessitate that a British court extradite a British citizen for a crime which would not be illegal in the United Kingdom represents an entirely unacceptable incursion into our British criminal justice system. Madam Deputy Speaker, in conclusion, I am not a lawyer. I think my constituents regard being a politician as crime enough, rather than being a politician and a lawyer. But to be a lawmaker, you do not have to be a lawyer. And what I would say, most of my constituents aren't lawyers either, but they smell that there is something not right in the exercise of the European arrest warrant. They want the British government to stand up for British citizens, and they want the freedoms and protections under the law that we have cherished for years.
Andrew Smith.